we're all back. Mr. Hussain, are you ready to make your submissions?
I'm ready to proceed. Let me begin by dealing
We're not hearing you. You're probably on mute.
No.
No, I am not on mute. Are you hearing me now?
I'm hearing you.
We hear Mr. Hussain, of course. Welcome, Mr. Hussain.
Thank you very
We
much.
hear you perfectly.
Are you hearing me, Your Honor?
I am hearing
Be frozen.
you.
Yeah.
That is exactly what happened to me when last we met. Perhaps you can give him a minute to log out, which is what I did. Then to log in, because if you notice,
Am I being heard?
Oh yeah, yes, you're back with us.
Yes,
You're just coming back in now, President. You were frozen.
Mr. Hussain, are you?
Yes,
Are you hearing me?
I'm hearing you. Should I begin?
I am not hearing you. I'm sorry. My earphones were not in.
Well, probably you could. Oh, I see.
Okay, I'm very sorry. Yes, Mr. Hussain, please go ahead.
I would like to begin by describing the basis of the CCJ's jurisdiction. And I want to frame my case a little wider than the narrow ground that on which Mr. Mendes framed this case. And that is, in my respectful view, the CCJ has a power under Section 6 of the CCJ Act and under Article 25 of the agreement to hear this matter as a question of right from decisions of the Court of Appeal. And I will develop that point as I go along because I am aware of the finality clause. I make this point in passing. This is not in respect of your original jurisdiction, so none of the case law that deals with the Vienna Convention is applicable in this case. This is in respect of your appellate jurisdiction. The agreement is incorporated by Section 3 into the laws of Guyana, and therefore, I think as a right, the appellants in this case are entitled to apply to the Court of Appeal. Now, to the CCJ. Now, this matter involves an interpretation of the Constitution, Section 177, coupled with other issues, but because there's a constitutional element to it, the fact that there are other issues does not preclude the CCJ from assuming jurisdiction. Of course, when you're looking at a provision that gives a right of appeal, you look at what is the subject matter of the right, and in this case is a constitutional issue. We have to deal with the unique importance of the CCJ as a final court of appeal and the requirement of the CCJ to give guidance that is vindicatory of the Constitution, that is the supreme law. We see also Section 6C is couched in broad and general language so as to bring within its reach every issue that has a constitutional flavor. Now, I know that the issue as of right applies in respect of matters that are criminal or civil, and these are civil proceedings, and if there is need for authority at all, Danny Marie, which is helpfully provided by my friend Mr. Jeremy, at paragraph 24, 22, and 26 paragraphs deal with the question of what constitutes civil proceedings. These proceedings deal essentially with the interpretation of 177 2B of the Constitution and 177.4, and the question of whether the Court of Appeal has the exclusive jurisdiction to hear and determine any question as to the validity of the election of the president, insofar as it depends. So the principal issue is in respect of the validity of an election of a president, insofar as it depends on the qualification of the person for election or the interpretation of the Constitution. Now, I accept absolutely that you can't have a situation where you go into the court and invoke the jurisdiction under 177, where you don't name a person so as to determine whether the person is qualified to be president or not. And that by itself and alone takes the case, causes the Court of Appeal to commit not only an error of law, but an error of jurisdiction. Now, I deal with the issue of a constitutional interpretation, because I say Section 6 of the Act and Article 25 of the treaty confers upon the CCJ prima facie jurisdiction to deal with the interpretation of the Constitution. And this is subject only to its displacement if it can be said that Article 177.4, the finality clause, applies to the decision in this case. So it's essentially a constitutional interpretation issue, unless, of course, it is excluded by 177.4. The second ground on which Mr. Mendez has pinned this case is the question of special leave. And I make the following comments in respect of that, which has been covered already, but I make them in passing. We rely on the Barbados rediffusion case. This case deals with a fundamental constitutional issue, namely the qualifications of a president. It impacts on democratic sovereignty and the rule of law. The third point I wish to make is, like, unlike other jurisdictions, in this case, both the CCJ Act and the treaty creates a jurisdiction for the grant of special leave. And this is where this case is very different from Grant and De Morgan and the other cases, where those constitutional instruments, whether in Jamaica or Mauritius, did not contain a special provision in respect of the grant of special leave. So my little friends, Mr. Jeremy and Mr. Amo, cannot respectfully rely on those cases because the different statutory regime. The second thing I say about those cases, and that is De Morgan, Grant, and Danny Marie, and Strickland, and Sanake. I make the following comments about those cases. Those cases are distinguishable on one or both grounds. And the first ground, of course, is the issue of there is no specific provision in the regimes of those countries that allows you to get special leave. But the second and more important issue in respect of the election cases for which leave was not granted was because of the historical law that informed election petitions. The composition of a legislature is a matter for the legislature. The legislature has in many Commonwealth countries, including Guyana, Trinidad and Tobago, and the UK, given this power from the Parliament to the courts. This power is extremely limited, and what they have done is, because they require expedition, what they have done is they have placed the Court of Appeal as the final Court of Appeal in some countries, and in the case of Guyana, the final Court of Appeal is the CCJ. So therefore, in my respectful submission, the reason why those other cases, why special leave was refused, was because they are election cases dealing with a historical situation where the jurisprudence was to determine them as fast as possible and therefore restrict the appeals to the Court of Appeal. And in the absence, in some cases, of legislation to grant special leave, they said no. Alternatively, the law applied the historical jurisprudence on election petition cases that, unless specifically stated, it will not go to an apex court, as the case may be. And all those cases are distinguishable on those lines. I am not going to repeat all of what Mr. Mendez said, whose submissions I adopt wholeheartedly, both orally and written, except to say that what has happened is, if you look Millards, or Your Honors, at the judgment of the Court of Appeal, and you look particularly at paragraphs 96, 96 and 110, found at page 3394 of the record and 3395.
Sorry, whose judgment is that? I am looking at it in a different format.
Judgment of Justice Reynolds, Justice of Appeal Reynolds.
Thank you.
I'm not going to read the contents of those two paragraphs. And then you put that side by side with the report prepared by Mr. Lowenfield of the 23rd of June 2020. Mr. Lowenfield says, I've taken guidance of the Court of Appeal in David against the Chief Elections Officer and others in the preparation of my report under Section 96 of the Representation of the People Act and providing advice required by Article 177 2B of the Constitution of the Cooperative Republic of Guyana. So what Mr. Lowenfield has done is that his report is informed. His report is informed by what is contained in the judgment of Justice Reynolds, Justice of Appeal Reynolds in the Court of Appeal. Now, that will be a plank upon which I will ask you to make other orders as we proceed during the course of this afternoon. But we say, Your Honors, this is the danger that has been caused as a consequence of the decision of the Court of Appeal in respect of 177. Justice DeWitt and Justice Jamada and Mr. President have all made their comments, all of which I agree with, and it shows very, very clearly the egregious results that have taken place and the impact it can have in respect of election cases. We accept absolutely the fact that election cases are special and there's a special statutory regime prescribed for them in all of these countries and in Section 163 of the Guyanese Constitution. We also say that when the election results are declared, GCOM now has the authority to declare the presidency, and it is upon that you now proceed with your election petitions, and dependent upon the outcome, if there is a problem at all in respect of the presidency, you go to 177 and you resolve it on the basis of 177.6. So for example, if there's a different result as a consequence of the election petitions going to the Caribbean Court of Justice, you can now invoke 177.6 to change the situation as the case may be. We say
Mr. Hussain, may I interrupt you, please? Were the election results, you just said when the election results are declared, they must then declare the president. As a question of fact, were the election results for the assembly declared?
No, Your Honor, the election results were not declared. So therefore, the election results were not declared. And therefore, I said when because it deals with fair, and therefore this use of Section 177 in any event suffers from the ailment of prematurity.
Sorry, Mr. Jerry, Councilman Hussain, I am wondering if you answered my brother's question as to the result of the election for the National Assembly as opposed to President.
Yes.
So I should make myself clear. The election for the National Assembly should first be declared.
Yes, but the question is, have they been declared?
They have not been declared.
Thank you.
Your Honor. I think I said so, but perhaps the audio is given, right? And it's upon that is a condition precedent for the president of GCOM or the chairperson to appoint the president. And it is at that point, if there's a problem, you go under the bifurcated system. That is the system of 163 dealing with election petitions. And if there's a problem in respect of the presidency and the result comes out differently, you go to 177 as the case may be. Now, we say that the decision of the Court of Appeal is not a final decision within the context of Section 177. And we say so for the following reasons, and I will list them numerically so I can get it straight. The first thing is that this is not an anismenic type of case, because anismenic deals with inferior tribunals, and we accept that absolutely. But this does not displace the central issue in this case, and that is a question of interpretation. You now have to go and look at the finality clause and interpret the finality clause. And the issue is not displaced by the fact that the Guyana Court of Appeal is a court of law. So notwithstanding the fact it is not an anismenic case, and the fact that it is contained in the Constitution, does not mean that an apex court cannot review the Guyanese Court of Appeal. The Guyanese Court of Appeal is a court of limited jurisdiction when it is exercising the powers under 177.4. It is a limited jurisdiction, and it is also an exclusive jurisdiction. And the finality lies only in respect of a situation where the court acts not in excess of its jurisdiction, and I will define what I mean by jurisdiction in a short while. The court under 177.4 is allowed the privilege of exercising an originating jurisdiction. The jurisdiction is limited to the narrow issue authorized by 177.4. And it is that focus issue, that is the qualifications of the president, taking into consideration the two other factors, which is the focus of any inquiry by the Court of Appeal of limited jurisdiction. This jurisdiction, as I said before, is exclusive. It is confined as to the validity of the election of the president. And this jurisdiction is even more limited by the draftsman saying to the court, in determining the validity of the election of the president, it must, insofar as the question depends on the qualification of any person for the election or for the interpretation of the Constitution. It is not to go beyond that. And if it goes beyond that, for all the reasons which have been stated by Mr. Mendez before, it acts outside of its jurisdiction. Now, the question of the finality clause does not stand, even though the Constitution is the supreme law. It does not matter. The Court of Appeal has not only misconstrued Section 177.2 by, for example, inserting the words valid, by dealing with the issue of matters not in respect of the qualifications of a president and other than that, and other matters, but it purported to decide matters outside its narrow limit. And the issues which is purported to decide are issues that go to jurisdiction, and even in the pre-anismenic situation, and I will demonstrate that from an extract of the judgment of Lord Diplock in Rakal. Even in a pre-anismenic situation, if you act in excess of your jurisdiction, a court that is, a court of competent jurisdiction, then in that situation, an apex court or a higher court is allowed to review your decision. So not are we saying alone that this is not an anismenic situation, which clarified the law and conflated errors of law and errors of jurisdiction, go to jurisdiction in respect of tribunals, but we are saying this is a pre-anismenic situation. Now, we say as well that this case is covered by one simple authority, and the authority I would like to refer the court to is the case of Lee and Asher's Bacon Company Limited. And I would like, if I may, to refer to you to the judgment of Lord Mance, which is found in the bundle of authorities at 2831 of the authorities. And if I may ask you, if I refer you to paragraph 87 of that judgment, it's a judgment of Lord Mance. But Lord Mance, when he wrote this judgment, also cited Lord Dipstock's judgment from Rakal. Now, the first thing I note about this judgment is this judgment does not deal with a tribunal. It deals with a court in Northern Ireland. It deals with a court that was adjudicating on regulations dealing with religious and sexual discrimination. And Lord Mance referred to the judgment of Lord Diplock, and this is what he says. In the case of inferior courts, where the decision of the court is made final and conclusive by statute, this may involve the survival of those subtle distinctions formerly drawn between errors of law which go to jurisdiction and errors of law which do not. That did so much to confuse the English administrative law before understanding. So what he says is once an error of law, once an error of jurisdiction is identified, once you identify an error of jurisdiction, even in those limited situations in the pre-dinosaur age of Anisminic, the courts would set the judgment aside, and that is the higher court. But more than that, Lord Mance dealt with this matter very succinctly at paragraphs 88 and 89 of the judgment. I'm not going to read all of it to you, I'm just going to summarize it as far as I can recall it. In this case, the Northern Ireland Court of Appeal delivered a judgment. The Attorney General asked, amongst other things, for referral of the matter to the Supreme Court of the United Kingdom. The Northern Ireland Court of Appeal did not perfect his order, but refused the referral. The Supreme Court says that the refusal of the referral to the Attorney General was a matter that brought significant injustice, and it was unfair. And therefore, as a consequence of that procedural error, the finality clause in the Northern Ireland Court's legislation could not be relied upon as a shutout in order to get to the Supreme Court. So here we have a situation where the case deals with a procedural error. Here we have a case where the case deals with a finality clause. Here we have a court of unlimited jurisdiction, or a court of jurisdiction, a court of appeal, not a tribunal. And this is a case where the court said the regularity of the proceedings are being affected, because what you have done is you have performed an irregular, you have made an irregular order, and the irregular order resulted in an unfairness and significant injustice. And therefore, in those circumstances, because it's a challenge to fairness and regularity in respect of a court of competent jurisdiction, I am going to invoke what Lord Diplock said in that case of Rakal, and that is invoke the pre-anisminic jurisdiction of errors going to jurisdiction. And secondly, I propose on the grounds of fairness, notwithstanding the fact is the procedural regularity, notwithstanding the fact that it dealt with the refusal to allow the Attorney General to go to a reference, and it caused significant injustice because of the fact that the person was denied the relief, the defendants were denied the relief which they were entitled to have. It dealt with a baker's case, and someone wanted to put in it a message which the persons found were odious because it deals with gay rights and all of that. So, my lord, this is an authority. This is an authority was decided in 2020 by the Supreme Court in the United Kingdom, and here is a high authority coming after Anisminic, coming after Cart, coming after Rakal, where the court permitted itself, that is the Supreme Court, to review a decision of the Court of Appeal of Northern Ireland on the basis that the error went to jurisdiction, and it resulted in some significant injustice, even though it is a procedural error. Now, I am not about, Your Honors, to look at the situation here, because much more eloquent counsel than I, like Mr. Mendes, for example, have already identified what is the significant injustice in this country. And I'm not going to deal with democratic sovereignty. I am not going to deal with the issue of the rule of law. I am not going to deal with the fact that what has happened here is that the Court of Appeal conflated an election jurisdiction under 163 with the jurisdiction in respect of the qualifications of President under 177, which will result in a manifest absurdity and which will not redound to the health and the benefit of the Cooperative Republic of Guyana. And that is as fundamental as you get. And therefore, in my respectful submission, you are entitled to grant special leave and to hear this matter as a matter of right, because the finality clause has to go. The court, this is not merely an error of law. If it's an error of law, fine. We have a question mark as to whether you can review it or not. And that is not for you to decide. The issue in this case is more egregious than the issue which the court addressed in Lee and Ashes. It goes to the heart and the soul of elective democracy in this part of the world. And I want to invite this court. This is your Marbury and Madison moment. And if I may use a cricketing term, I ask you to step out of your crease, and for reasons which I will do otherwise, I will ask you to make what the people normally describe as ex-cathedral statements, but I will ask you to opine on a number of issues consonant with the jurisprudence which has emanated from the other apex courts, the Privy Council, in respect of situations where there is gross perversity, which is likely to undermine the rule of law and democratic justice. Now, I say to you that Lord Mance went on to say that this kind of irregularity and this kind of unfairness was not contemplated by Article 61(7) of the New Zealand legislation, Northern Ireland legislation, and therefore, as a consequence of that, he's not going to allow the reliance upon the finality clause. Now, I want to deal principally with the submission which I am most interested in, and I use the word. This is your Collymore. This is your Collymore moment. This is your moment of Marbury and Madison. This is your Anasminic moment. This is the moment where I think the Caribbean Court of Justice has an opportunity to deal with this issue and to deal with the uncontested facts of this case. Now, my learned friend, Mr. Amor, raised an objection in respect of the affidavit, second affidavit filed by, I think, the appellant Barrett Jackley. Apex courts always allow that. Justice, Your Honor, Mr. Barrow, Justice Barrow, will of course be familiar, if not participating in the case of Bakongo. And affidavits were filed all the way to the Privy Council. And I know it because I followed that case very keenly. Mr. Fitzgerald was counsel and Lord Judge Roger delivered the judgment in respect of the injunction. And the affidavits were filed all the way to the top. What is not being challenged is that what is contained in that affidavit is substantially true. But you don't have to accept all of it. What you have to merely accept are the following facts. First of all, there was an election. There was this matter came to this court, firstly, in respect of the holding of election. There was an election. There was the GCOM order of the 4th of May, and I say this respectfully, the GCOM order cannot supplant the Representation of the People's Act, nor can it supplant the Constitution, because those are legislative regimes occupying different hierarchies in the order of things in respect of how elections are going to be conducted. There is amended GCOM order, no problem about that. There's the CEO's elections report of the 13th of June 2020. There's a statement by the chairman of GCOM on the 16th of June 2020, with which he gave the CEO until the 18th of June 2020 to submit a report. There is, of course, the Court of Appeal hearing on the 19th of June 2020. There's the Court of Appeal judgment of the 22nd of June 2020, and all that is missing is the 23rd of June 2020 report of the second report of the Chief Elections Officer. Now, that is the only issue which I want to address in Mr. Bharat Jagdev's affidavit. Now, you have a situation here where all of those facts are not contested. And in that regard, I ask you to look at the following factors. Look at, first of all, the delay in holding these elections. Firstly, look at, secondly, the fact that it's almost 3 months and the election is in Guyana for the National Assembly is still a highly contentious and disputatious matter. Look at the fact that this is the second occasion which this matter is reaching this court in a situation where, in both instances, I can draw the conclusion that the cases arose out of perversity, one way or the other, on the part of the executive, or alternatively on the part of the Chief Elections Officer, and a judgment patently wrong on the part of the Court of Appeal, where they overextended themselves well beyond the parameters of a responsible court. And I don't expect you, of course, to say that. We also have a situation where the Chief Elections Officer said there were some 15,000 votes. That was the difference in District 4, and subsequently withdrew that and dealt with 115 votes that was wasted. And it is pellucid that this report of the Chief Elections Officer, which was delivered on the 23rd of June 2020, which finds justification, which finds anchorage, and which was birthed in the Court of Appeals judgment, is really an attempt to eviscerate the heart and soul of democracy in this country that is struggling for its survival, as the case may be. And I ask you in respect of that that is the perfect storm for an apex court to leave the safe chambers of where it is and exercise your judgment in accordance with the law. What I'm asking you to is not to go outside of what is permissible by the law. The courts have a number of things that it is guided by. It is guided by common law. It is guided by statute law. It is guided by modification in some instances where it modifies laws either pursuant to the Constitution or savings clause, as the case may be. It has in INCO, written, the case of INCO Europe, written parts of a statute where the draftsman engaged in a Homeric nod. It has also made orders that are new, like for example, Mariva injunctions and antempelon orders. It's a constantly evolving law, and it is of course has to take into consideration the issue of precedent. I am not urging your honors to act recklessly. I'm asking you to act maturely. I'm asking you to act within the presidential direction which was provided to you by the Privy Council in a number of cases. I'm asking you to do that because you have to historically intervene and make some of these statements that I describe as tentative, because I draw that from the judgment of Brantley, which is before my lords, before your honors, at page 2910. Sorry, I beg your pardon. Yeah, 2910 of the bundle. And Brantley is a case, of course, dealing with elections that came out of St. Kitts Stevens, and my little friend Mr. Mendez is very familiar with it. And what happened in Brantley was that the government of the day published a report relating to the boundaries on the eve of the elections. This report was being requested over and over. The Elections Commission did it, and they are appointed by the government. The court, there's an interlocutory appeal to the Privy Council. And the interlocutory appeal was based on leave, on special leave. The matter was decided, and the Privy Council gave a judgment. And the Privy Council said, look here, the election should be conducted on the basis of the first list and not on the basis of the second list, because there was a question of timing as to when the second list was published. And the judgment that was delivered is the judgment of, I think it was Lord
Hodge.
I think about
Lord Hodge.
Lord Griffith, is it?
I think it's Lord Hodge.
Or Lord Hodge. No, Lord Hodge. Right? Lord Hodge. That's correct. Thank you very much. Lord Hodge. And this is, I draw your particular attention to paragraphs 3, because this is an interlocutory application. An interlocutory application. Secondly, paragraph 4. Consent was of the leave was granted by consent of the parties. And this is what Lord Hodge said. The board has concluded that the dissolution of the National Assembly occurred before the impugned proclamation was made. Accordingly, the proclamation, if valid, did not govern the election which followed that dissolution. But the appeal also raised important constitutional questions on which it is expedient that the board express its at least tentative views. Those questions are: 1, whether if there was a deliberate attempt to exclude the review by the courts of the Constituency Boundary Commission, and 2, whether the publication of the impugned proclamation in the Gazette after the grant of the interim injunction was unlawful and therefore has no effect. Now, at page 2944, the board dealt with the issue at paragraph 25 of the publication of the proclamation. It says it is no part of the board's rule in this appeal against an interlocutory order to make any findings in relation to the appellant's substantive case. That the way in which the former governing party sought to bring into effect the CBC's report, that is the Constituency Boundaries Commission report, to alter the constituency boundaries. And then the board went on to say this. The first issue is whether if there were such attempts to prevent access to the courts to review the legality of the impugned proclamation, that attempt was unconstitutional and thus unlawful. Now, that did not have to be decided because of the fact that what the government sought to do, as is clear from the judgment, is it published the report in an attempt to deny the citizens of St. Kitts Nevis access to the courts. In my respectful submission, what the Court of Appeal did here, and what this application to the Court of Appeal did in its limited jurisdiction, an exclusive jurisdiction for which it said it's final, and which we say is perverse and wrong, is to deny access to the Caribbean Court of Justice and to perform a Heimlich maneuver and bypass constitutionally prescribed mechanisms in which elections have to be decided. So it resulted in the same kind of egregious results that Justice Jabala described in the several questions to my very learned colleagues and friends, and my personal friends, Mr. Armor and Mr. Jeremy. And that is, you are faced with a situation where you have different results from the CCJ on the election petition as against the Court of Appeal. And what do we make of that situation? It goes towards absurdity. Now, I'm not going to read.
Sorry, Consul. Aren't you finished now? I thought that you were well over your time.
Well, I'm going to finish 10 minutes. No, just 10 minutes. Can I have 10 minutes? Mr. Amor got 50 minutes.
No, you don't get the same time like Mr. Amor.
Okay, well, I
see. Because we had questions from Mr. Amor and took him over, well over. No, we don't have any questions for you in that intensity. Yeah?
Well, can I just sum up in 5 minutes?
Please.
I thought
sum up in 5 minutes.
Actually, I thought that your peroration about this is our Marbury and Madison moment, and then stepping outside our crease, I thought that was your peroration, but...
Well, I have to do like Justice Marshall and Marbury, or the Counsel Justice Marshall, like Adams, and probably develop the points a little bit. But it's all in the skeletal arguments. I just want to review it very briefly. What we ask you, what we focus on are the following things. To focus on making some statements that are tentative in respect of decisions taken in purported compliance or conformity with the order of the Court of Appeal, which is the subject matter of this appeal, and the facts are not contentious. We ask you, secondly, to render the entire order and the judgment of the Court of Appeal void and of no effect, and to set it aside. We ask you to state emphatically that the issues relating to validity of votes and final credible votes or the election of a member on the list of the House of Assembly are matters reserved by the Constitution and the law for an election petition. We say to you finally that if you look at the case of Pratt and Morgan at pages 25 to 27 and at paragraphs 5, 9, 25, 26, and 32, what you will see is the Privy Council once again providing guidance in respect of how these countries should treat persons who have been incarcerated for 5 years and the death penalty was not carried out in respect of them. And therefore, we say to you that, finally, we say to you that we would like you to read the case of Gore against Bush from the American Supreme Court and look at the contents and the judgments of the Supreme Court and appreciate why it is election cases must be heard quickly, and why is it that this process in 163 and 177 was developed, provided that the courts in the states of 177 act within their jurisdiction. I can say a lot more, but I have said what I have to say, and I think your honors have got the gist of it, and I thank you very much for the opportunity of addressing you.
Yes, thank you very much, Mr. Hussain. Mr. Mendez, you have no more than 20 minutes.
Thank you very much, Your Honor. I will most likely be much shorter than that.
Thank you.
Just some very quick points in answer to His Honor, Mr. Justice Jamada. My learned friend, Mr. Jeremy, had said that, or was suggesting, I think, that GCOM could not be considered part of the executive because under Section 22 of the Election Laws Act, GCOM was given, in effect, legislative power. But of course, it's not unusual that ministers are given legislative power under legislation to make regulations, and sometimes the president or the governor general is given legislative powers to make regulations. But it's never thought that they have thereby become part of the legislature. They still remain part of the executive. As far as my learned friend, Mr. Simon, is concerned, he made the submission that, now this is on the question of the jurisdiction of the Caribbean Court of Justice. He made the point that it is within the prerogative of a sovereign legislature to decide that an appellate court or the decisions of an appellate court are final. Of course, no one disputes that, but we are not dealing with a court in this instance exercising appellate jurisdiction. The ordinary case is that you have a decision, a case that goes before the High Court first of all, and then there's an appeal to the Court of Appeal. The Court of Appeal determines the case, and then the legislature says that's enough. The decision of the Court of Appeal is final. Usually you're dealing with a situation where, first of all, the High Court, being a court of unlimited jurisdiction, exercises its jurisdiction, and then the Court of Appeal decides the appeal. Sometimes it's limited to points of law, sometimes not. But in any event, usually the Court of Appeal will have the same powers of the High Court in relation to the case. The legislature then says that decision is final. in those types of cases, you're dealing with courts that have very broad jurisdiction to begin with. What we're dealing with here is not the Court of Appeal exercising its appellate jurisdiction. We're dealing with the Court of Appeal, which has been assigned a specific constitutional role, and indeed a very closely defined constitutional role. That is what we're dealing with here. Now that is, I juxtapose that to what my learned friend Mr. Armour said, and again quite rightly, where he said that, or he reminded you that as an appellate court, the Caribbean Court of Justice is a court of limited jurisdiction, and therefore you must be very careful what jurisdiction you assume for yourselves. That is to say, you must look to the CCJ Act and decide what jurisdiction you have. Well, that is the same thing that applies, and he must apply that as well to the Court of Appeal. He must accept, having made that submission in relation to the Caribbean Court of Justice, that the Guyanese Court of Appeal must also ensure that it is exercising only the jurisdiction that it is given. But having said that, he nevertheless says that if they then exercise a jurisdiction that they do not have, there's nothing anybody can do about it. You can't appeal to the CCJ. You must accept that they have decided to exercise a jurisdiction that they don't have, and that is it. Just putting the problem in that way, I respectfully submit, would indicate that there must be something wrong with the submission that this finality clause prevents an appeal to the CCJ. Now, that brings me to the series of cases that my learned friend Mr. Jeremy has relied on, which he says supports the proposition that this court does not have jurisdiction, and that is a series of cases from the Privy Council that were listed and mentioned in the decision of the Privy Council in Danny Sylvie Marie. Now, my learned friend Mr. Hussain has dealt with these cases, and he has distinguished them, as far as I would respectfully submit, quite adequately. But if I may make this point, in all of the cases mentioned in that paragraph, if I can ask my learned junior just to find that paragraph from the decision, it's in paragraph 50 of the decision of Danny Marie, and you will find that at page 3244 of the record. The decisions of the Privy Council in Senanayake and Navaratna, Strickland, Devanir, Thiburge, and Azu. Those are the cases of the Privy Council that were mentioned. And in each of those cases, the Privy Council was saying that we do not have jurisdiction to deal with an appeal from the Court of Appeal, or maybe from the first instance court, it all depends, because there is a finality clause that says that is the end of the matter. But all of those cases were dealing with election petitions. In other words, a case which started in the election court, and usually it's the High Court that is given the election petition jurisdiction, and then you go to the Court of Appeal, and then somebody is now trying to appeal to the Privy Council, and the Privy Council says we can't entertain that appeal. But in none of those cases was it being said that the High Court, that is the election court, assumed a jurisdiction which it was not given. That wasn't said at all. Nobody said that you weren't exercising your election petition jurisdiction. No one said that you weren't exercising the jurisdiction to determine whether the election was unlawful or not. That was not at play in the case at all. The one that came close to dealing with the point that we are required to deal with in this case, that is Senayakne and Navatne, which is the one that is mentioned at paragraph 50 in the judgment in the Mari case. This is what it said: a similar result was reached in Senayakne, where it was held that the finality clause applied even to jurisdictional challenges. Now, that is the only decision, that is the only one of those decisions that addressed the question of a jurisdictional issue. But what was the issue in that case? In that case, you will see at page 3267 of the record, just at the second paragraph from the top, this is in the head note, it is stated, on appeal from a decision of the Supreme Court affirming a decision of the election judge on the ground that he had acted without jurisdiction since he had acceded to an application to amend the petition out of time. That was the issue that we were dealing with in that case. The judge had allowed the petition to be amended out of time, and the Supreme Court had said that he had acted without jurisdiction in doing so. And there was now an appeal or an attempted appeal to the Privy Council in those circumstances. That is the error of jurisdiction that they were talking about here, amending a petition out of time. That was not a case where it was being said that the election judge did not have the jurisdiction at all to begin the inquiry. And that is what we are saying in this case. More than that, none of those cases dealt with the unique situation that was articulated, in this case, that was articulated by Justice Jamada, which is that you have an admitted situation where the issue that has been raised in this case, that is whether GCOM acted lawfully or not in accordance with its own order, that issue can go before the election court. And if it goes before the election court in this case, then you can appeal all the way up to the CCJ and have it determined. But the Court of Appeal under 177 accepts jurisdiction to deal with that very issue. One of these courts has the jurisdiction. If it is that this court finds on a proper interpretation of the Constitution that the High Court has that jurisdiction, then you can't leave it alone, with all due respect, and say, well, the High Court of Appeal, if it wants, can assume that jurisdiction, make determinations, and there's no appeal, when you can take that very same issue and take it right up to the CCJ. That the law cannot be left in that state, and that in itself would indicate that none of those cases that my learned friend Mr. Jeremy has cited can assist the court in resolving this issue. And of course, I need not mention the fact that this is the final court, and you are of course not bound by the position taken by the Privy Council in those cases, particularly since in those cases the Privy Council is sitting far away from the jurisdictions that they had to deal with. But this is an indigenous court. This is the Court of Appeal of Guyana, the final Court of Appeal of Guyana, sitting, albeit not physically in Guyana, but in a region to which Guyana belongs. And we are about forging a new jurisprudence. So we have to, this court must resolve this conflict in jurisdiction between the Court of Appeal and the High Court. And it cannot, in these circumstances, say, well, this finality clause applying only to decisions within jurisdiction bars this court from hearing this appeal. Now, there are a couple other points that I would wish to address very briefly as well, Your Honors, but I'm getting confused with the amount of paper that is being put in front of me at the moment. If I may just deal with them. With all due respect to my learned friend, Mr. Armour, I believe it was his submission that in interpreting the provisions that deal with the contours of your jurisdiction, you must apply international law principles. With all due respect, we are dealing with an act of parliament, a domestic act of parliament. And insofar as the treaty is concerned, that treaty has been incorporated into the Act of Parliament and given the force of law. So what you are interpreting in these circumstances is not a treaty. You are interpreting domestic legislation, and therefore they are subject to the normal canons of construction that apply to domestic legislation. Now, with regard to my learned friend, Mr. Simon's proposition, which is in answer to questions put to him by the court, that you can bring proceedings under 177 at any time, just consider the absurdity of that proposition. If you can bring it at any time, then you could bring it at any time, as many times as you want. As long, the only limit to the number of times that you can bring it before the court, before the election is held, is the creativity of lawyers. So as long as lawyers are creative enough, then you can have a plethora of applications being brought to the court under under Article 177, all before the election is held, thereby delaying the election for as long as possible. With all due respect to my learned friends, that cannot possibly be a proper interpretation of the law. I believe this would be the third to last point that I'm about to make, and it is this: as far as and this is what distinguishes this case as well from the decisions of the Privy Council that my learned friend Mr. Jeremy relies on. If it is that the Court of Appeal under 177 can assume jurisdiction in relation to matters that properly concern the validity of votes for the National Assembly, then what can happen is this: the election is declared, there is no challenge to the election to the National Assembly before the election court under 163, but given that there is no time limit, because no rules have been made for bringing an application before the Court of Appeal, then 1 year later, 2 years later, you can approach the Court of Appeal and say, well, I now want to invalidate the election of the president on the basis of my interpretation of votes cast. I now want to say that the votes that were cast were invalid, because I'm asking you to interpret 172 to mean valid votes. And I am saying that the votes are not valid because an order made by GCOM was not complied with, or the provisions of the Representation of the People Act were not complied with. The point is that what the Court of Appeal has allowed itself to do in this case is to treat the phrase "more votes cast" as if it was an empty vessel, and that they can fill it with anything that would affect votes, which would mean any provision of the Representation of the People Act.
Can I just...
Yes, Your Honor.
2 points. One. Is it correct that under the section 1, whatever it is, under the election petition regime, there are fixed statutory time limits within which you can challenge the validity of an election?
That is correct.
And those time limits, I'm assuming from my own, when I say knowledge of the region, well, not Guyana, I'm assuming those are relatively short. Do you know them offhand?
In Guyana, it's 28 days, as I recall, Your Honor. And that is set by...
Is the Guyanese jurisprudence also strict, generally, about those timelines? I know generally election petitions in the law I have done, that not only are there timelines that are short, but the courts have taken a rather strict approach to extensions of time. Is that also the jurisprudence in Guyana?
Yes, Your Honor. This court decided in the Ram case very recently that the timelines have to be followed very strictly. And once the 28-day period passes, you cannot challenge the election anymore. That case dealt with an allegation that a member of parliament was not qualified to be elected. A 28-day period passed, and it was some years later, there was an attempt to raise the question whether he was qualified to be in the assembly and to vote. And the court said, this court said that it was too late to bring that complaint before the court, even if you only discovered the disqualification after the 28-day period. So
now,
this court
no such limitation would apply if the Court of Appeal under 177 had an exclusive, unreviewable power in relation to validity of votes. Is that correct?
That is correct, because Parliament has not passed any rules under 11.5, which would govern as the section says, there's nothing that governs who can bring an application, when they can bring an application, or how the application is to be dealt with. There is the conditions that would apply to the application.
I want to ask one last thing, if you would indulge me. in 177, it says, it doesn't use the word valid, right? The word valid never appears. It's votes counted. Is that right? Is that the language? Now, is it that, would you say that because the section 177 is a demon section, that presumes a quantitative assessment, and the qualitative assessment, i.e. as to validity, is reserved for the 163 regime? So in other words, you are one of those who have said, I believe, and several others, that if what the Court of Appeal had done in interpreting 177 was to say votes validly cast, that is somehow innocuous, I am concerned that it may not be innocuous because it is introducing a qualitative element in a section which is a demon section based on a quantitative and qualitative assessment made at an earlier stage in this election process. How do you respond to that?
What I say is that when you read the votes, when you read the phrase, if more votes are cast in favor of the list, that phrase or that determination as to which list more votes have been cast, that is determined by another process. That is determined by the process under the Representation of the People's Act,
and that includes both qualitative and quantitative assessments.
That is correct. That is correct.
Because so I am asking, because 177 has deemed, in other words, where you have more than one, that qualitative and quantitative assessment having been completed through the court system if necessary, the certification and declaration is deemed. So is there, what I'm asking is, if that is correct, and it may not be, is there room for any form of qualitative assessment in relation to validity?
Under 177?
Yes, under 177.
No, that's what I'm saying, Your Honor. The process for determining if more votes have been cast for a list, that process is set out in the Representation of the People Act. There are a number of rules there that would tell, for example, the presiding officers at the election which votes to spoil, which votes to reject, and so on. And similarly, when the returning officers are taking the statements of the poll and tabulating them, they must abide by rules as well. When there's a recount under the Representation of the People's Act, there are rules which tell the person who is doing the recount, the returning officer, which ballots to reject and which ballots to accept. For example, one of the rules of a recount is that if a ballot does not have the official stamp on it, then you reject it. So there are rules that tell you which ballots are valid and which are not. And at the end of that process, you tabulate it and you get a result. So that is determined under the Representation of the People Act. And it is what you are determining there is not the votes cast for the president. You are expressly determining the votes cast for the list. And the body which can then adjudicate upon any disputes in relation to that count is the High Court. So you have a separate.
I understand, Mr. Mendel. Yes.
For determining that.
So can I ask, why is it that adding the word valid in 177 is of any value? Because if you get past stage 1, at stage 1, the votes counted are gone through the process of verification.
Yes.
So that the section, why was there a need to even interpret that section to say it must mean valid? It is intended to mean votes. The words are votes cast. the qualitative assessment has been done. I'm asking, just because everybody has told, certainly us so far, well, valid votes cast adds nothing. I don't understand the regime why you need to put a quantitative rider when that has been completed and this is a demon section. So I just want to know what your thoughts are.
Well, Your Honor, the only way that I can seek to explain it, because as my understanding is that the exercise of determining which list got the most votes is determined outside of 177. My only understanding of why it was important for the applicant, that is to say the first respondent, Ms. David, in this case, to come to the court to get the court to put the word valid in there, is that it was a vehicle to try to persuade the Court of Appeal to look at the way in which they thought that votes were being rendered invalid. That is to say, because...
And therefore, Mr. Mendez, if that is right, then does the introduction of that qualitative word, is that the thing that has created this confusion, because it has introduced a qualitative element to an assessment that had no part to play in the constitutional structure and the clear and plain language of 177, which says votes cast, because it assumes the qualitative assessment of validity has already been done.
That is correct. That is correct, my lord. But the point is that we ought not to have gotten to the stage where I'm sorry, we ought not have gotten to the stage where the Court of Appeal was even considering whether more votes cast meant more valid votes cast, because the real question that was being asked to be determined had nothing to do with the interpretation of the Constitution. The real question was whether GCOM was violating Order 60 of 2020. And therefore the Court of Appeal ought to have said, this is not for us to do. That's for the High Court, and so therefore we are not entertaining it at all. The point is that they managed to be persuaded by the advocacy of my opponents that if you put the word valid in there, then that allows you to siphon into the 177 anything that might render the votes invalid, including in this instance, and this is all they were interested in at this point in time, the GCOM not following the order, not making a determination as to the credibility of the votes. That was where the problem was. But what the court ought to have done is to ask itself, what, as my learned friend Mr. Armour said that they should do, what is the question that we are being asked to determine? Is the question an interpretation of the Constitution? Or is the question dependent upon the interpretation? Or is the question dependent upon the interpretation of something else? And if they had asked that question, they would have appreciated that the question is something else, and therefore we do not have jurisdiction. But the point is, Your Honor, at the end of the day, by putting in the word valid there, and therefore assuming upon them, assuming to themselves or arrogating onto themselves the qualitative and quantitative type of assessment that is provided for under the Representation of the People Act, they were encroaching upon the exclusive jurisdiction of the High Court. And that is why we say that it is important for this court to correct that and to make clear exactly what the functions of the Court of Appeal and the High Court are, respectively, in relation to elections. There are just a couple more points. One is that Her Honor, Madam Justice Rajnathli, had asked about the my learned friend Mr. Jeremy about the case of CARE against the Election Commission of India. Just to point out that that case was mentioned in the Sikumar Singh case, and you will see that at page 1377 at letter I, and you will see Chief Justice, I think it is Chief Justice Bollas again.
Yes.
Chief Justice Bollas saying, the decision in Punaswamy was followed by the Supreme Court of India in CARE, where the wider meaning of the word election was adopted as being applicable to the expression relating to or in connection with the election of the president. Accordingly, it was held that Section 18 of the Presidential and Vice Presidential Election Act must be construed to mean that the time for the exercise of jurisdiction by the Supreme Court to inquire into and decide doubts and disputes arising out of in connection president election was after the entire election process was completed. You see that at page 1377 at letter I. And the last point that I would wish to address is, well, 2 points. If I may clarify, Mr. Justice Jamadar asked my learned friend Mr. Hussain the question whether the election has been declared. If I may just join with him to say that what has happened is that there has been a recount, and the results of the recount have been made public, and indeed the results of the recount have been attached to the affidavit of Ms. David in these proceedings. And the results of that recount shows that the PPP won. But there has not been a declaration of the election, because what now has to happen is that the chief election officer has to take the results and then allocate the seats in the National Assembly in accordance with the formula that is provided for under the Act. And then that goes to the Commission, and then the Commission gazettes the result. It is at that point in time that the election is officially declared. But at this point in time, the results are known, but they have not been declared in the way that I have just indicated. Which takes me to the very last point, and it is in relation to my learned friend Mr. Armour's objection to the introduction of evidence that occurred after the proceedings in the Court of Appeal. And I'm grateful to all of the references that my learned friend Mr. Hussain has given to the court of the occasions in which evidence is put before the appellate court. And in this case, there couldn't possibly be any objection that the Land Marshal objection, because of course this is evidence that was not available at the time the appeal was being heard. It was evidence that occurred the day after. And with all due respect to my learned friend, what the Chief Elections Officer did, who is a party to the proceedings, was that he acted on the basis of the Court of Appeal's determination, expressly acted on the basis of the Court of Appeal's determination, even though there was a stay. And I respectfully submit that it is not a big ask on our part to ask the court to say, well, if the Court of Appeals did not have in the first place the jurisdiction to give the guidelines, whatever they were, whatever Mr. Lowenfield thought that they were, but if they didn't have the jurisdiction to give those guidelines, then he ought not to have taken that step. He ought not have taken it in the first place because there was a stay. But if the decision of the Court of Appeal is set aside altogether because they had no jurisdiction to give it, then likewise his report ought to be set aside as well. Unless there's anything further, Your Honors, those are my respectful submissions.
No. Yes, thank you, Mr. Mendez. I see a number of hands raised. Honorable Attorney General, is there something that you wanted to say?
Yes, please, Your Honors.
Yes.
Just to clarify some aspects of our legislation. Your Honor, Mr. President, you, Justice Jamadar, and I think Justice Witt, are organizing over what is essentially one vehicle under our laws that takes the result to the president's election and the other to the elections of members of the National Assembly. The person that is common to both is the Chief Elections Officer. And under Section 96, his remit is to calculate valid votes. That provision has been constitutionalized by Article 162(1)(b). The reason, as Justice Jamadar was inquiring, what's the reason for introducing valid in Article 177? It's simple. Fraudulent votes. The election produced fraud of an unprecedented scale in the history of elections in Ghana. And therefore, every precaution had to be taken to ensure that in the presidential elections also, in Article 177, that more votes cast, if more votes cast, should be crystallized.
Mr. Attorney General, this evidence was given by Ms. Davis in the matter below, that there was massive fraud in the elections, was it?
Yes, please, Your Honors. I'm not sure why Mr. Mendes made it introducing those elements. In fact, it was I.
With all due respect to the Attorney General, there was no evidence given. The only evidence that was given was the letters sent by Mr. Harman to the Commission. There was no evidence. It was just letters that he had written making complaints.
That's not so.
Listen, wait. We don't want to. Just now, Honorable Attorney General, we don't want to get into that. I understand you to be saying that there was a reason why the term valid was inserted.
Sort to be interpreted to insert.
You were saying that that is because there was massive fraud.
Yes.
And Article 163 is the vehicle that deals with an interrogation of those issues.
No, please, Your Honor. As I said to you earlier, the president is not a member of the National Assembly, so there's definitely a separate jurisdiction for the election of the president.
So when a vote, just now, when a vote is cast, there are two different machineries for assessing the validity of that vote?
Your Honor, let me explain this to you. It's one election. The same votes that elect the president are the votes that elect the members of the National Assembly.
Yes, we know that.
The National Assembly, what happens is that you take the total number of votes cast, you divide it by the members of the National Assembly, the number, and you arrive at an electoral quota. Now that electoral quota is used to determine the allocation of seats.
Yes, we know that. We know that.
So that's a different process using the same votes. In relation to the president, it's provided in Article 177 that every list or each list of candidates should designate one candidate who would be the presidential candidate. So it's the same amount of votes would be involved.
And it's the same process.
Yes, please.
Yes.
And the same process.
And that process is cognizable by Article 163.
And Article 177 in the case of the president.
But how do you separate the two?
They're not, well, they're separated in the sense you have to determine which presidential candidate designated by a list of candidates won. And that is determined by which list of candidates had more votes cast for it. But that has been working from time immemorial. We never had a problem, but nobody has a problem with that.
Yes. Okay.
That has worked effectively in Ghana.
Thank you, Mr. Williams.
Your Honor, Mr. Yes. President, if you just allow me quickly, there was this contention about the CCJ could have jurisdiction because of the special jurisdiction rule that could allow you to access the CCJ. I just wish to say that all of the sections in the CCJ Act, Chapter 307, they are all subject to Section 4.3. And that's because Section 4.3 says nothing in this Act. And nothing in this Act is interpreted to mean that all other sections are subjected to that, including Section 26 that talks about modifying, etc., adapting, and the like. And overridingly, the Constitution is supreme. It's supreme so that when your honors are asked to grant special leave, this is in effect asking your honors to use your power to grant special leave to overrule Article 177.4 of the Supreme Law of Ghana. And that's not a practice that is normally seen, Your Honor.
Yes.
But
Mr. Williams, I didn't give you this time to continue making submissions. I
Yes,
thought you just
yeah.
wanted to clarify
Clarify.
something.
Thank you, Your Honor. If nothing else for me, thank you very
Yes.
much.
And who is using Mr. Keller's device?
That's me, Mr. Jeremy.
Yes, Mr. Jeremy, is there something you wanted to clarify?
Yes, just two matters, if I may.
Yes.
Your Honor, Mr. Mendez described the authorities which Mr. Amo and I relied on in terms of the question of finality as being all election petition matters. And he cited Danny Sylvie, versus Marie. Now, I'd just like to correct the record. That case was not an election petition matter. It was concerned with the eligibility of a person to be nominated. And that question was dealt with outside of the context of an election petition. That's one. And the second one, in just a minute, I'm not going to go into half an hour as Mr. Mendez did. The second matter, my lord, I believe your lordship asked a question of me when I was on my legs. And that question was, do I know of any case, could I point to any authority where a challenge to an election was had before the election? On my legs, I was unable to do so, but with the assistance of Mr. Mendez, I now draw your lordship's attention to that case, the Privy Council case of Danny, Sylvie, and Marie, in which the challenge to the nomination, the eligibility to be nominated, was dealt with, in fact, outside of an election petition context before the election. And that is all that I wish to address your lordships on.
Yes. Okay. Thank you. Mr. Khan?
May it please the court, mine is a housekeeping request if it pleases the court. I wanted to crave the court's indulgence to lay over my speaking notes because there were some matters which I addressed which I don't believe the court has the benefit of, and I would endeavor to do so by tomorrow morning, the latest.
Yes. Mr. Amo?
Most grateful.
You still on mute? Yes. No, you're still on mute. Mr. Amo?
Yes, I'm.
It's still on mute.
You're off now.
Right.
Yes, I think I have resolved it. Thank you, my lord. My lord, just two short points. One, my learned friend, Mr. Mendez's submission in relation to my reliance on the agreement which boots the Caribbean Court of Justice. I just want to make, for the sake of emphasis, the point that whether or not the Caribbean Court of Justice agreement is part of the domestic law of Guyana does not remove the burden on this court to appreciate that the court derives its jurisdiction from the agreement and therefore has to look to the agreement to find the limits of its jurisdiction. That's my first point. And my second point, my lord, I may have heard wrongly. I thought I heard Mr. Mendez suggest, and my words, not his except for one, the word siphoning, something to suggest that the order of the Court of Appeal allowed the siphoning of votes in. And I just wanted to say that I hope that is not a comment on the bona fides of the judges of the Court of Appeal, because I would not want to be associated with that at all. That was
neither would I, Your Honor. I think I heard that myself, and I was particularly
Your Honor, Mr. Jeremy and Mr. Amo both heard wrongly. I did not say any votes were being siphoned in. What I said was that by using the word valid, what they allowed was that the processes for determining the validity of votes, in this instance, by way of the order of GCOM, was siphoned into the process in 177. That is what I said.
Yes. Well, gentlemen, thank you very much for your submissions. This has been a long day, but we appreciate all the submissions that have been made. We also appreciate the need for expedition on our part. Naturally, we'd want to read and assimilate all the submissions that have been made and the authorities as best as we can, and try to juxtapose the need to do that with the need for expedition. During the break, we consulted among ourselves, and we are optimistic that we will give a judgment in this matter next Wednesday at 3 p.m. So we will adjourn until next week, Wednesday. That is the 8th of July at 3 in the afternoon. Thank you very much.
Your Honors, could you just clarify that the orders that you have made previously continue?
Yes, the conservatory orders that we made at the case management conference, those orders are to continue until the decision of the court next Wednesday.
Much obliged, Your Honor.
Madam Deputy Registrar.
Thank you very much, Honorable President Saunders. This court stands adjourned. Thank you much.